This meeting is information sharing meeting, and the Department of National Cooperative Governance will lead us in terms of giving us a contextual sort of background as to the amendments that are proposed to the Municipal Systems Act. And with that, colleagues, are there any questions you'd like to ask members for clarity purposes before we will move over to the presentation?
No questions, Chair.
None. Okay, thank you. So I immediately hand over to Mr. Machu Peng to commence with the presentation. I don't know if you would like us to flight the presentation or whether you're going to do so yourself. Please let us have an indication. We are quite ready to assist, but we also have technical assistance available. So if any member or one of our guests require assistance, you can indicate so. We will make it possible that we all have a smooth and able interaction with our meeting. Thank you.
Thank you, Honorable Chairperson and honorable members of the Provincial Legislature. Chairperson, we will request that the Secretariat from the Provincial Legislature flight the presentation for us. As I've indicated, my name is Tebogo Motlasuping. I'm the Executive Manager responsible for Municipal Human Resource Systems at National Copter. I am with the colleagues here with me, and the colleague that is going to make a presentation today is Mr. Jackie Maepa, who is responsible also for this piece of work in terms of policy formulation. And I also have Mr. Nsamula Mate. I also have Ms. Nakedi Munyela and Ms. Tina Andres, who will then be assisting us in relation to engaging with the Portfolio Committee for purposes of clarity and answering questions. Without taking much of your time, Chairperson, with your indulgence, may I please hand over to Mr. Jackie Maepa, who will be taking us through the presentation. Thank you.
Thank you, sir, and welcome to your team. Yeah, please proceed.
Good morning, Chairperson, honorable members. Without much delay, let me just shoot into the table of contents. At a glance, our presentation will deal with the background to this bill that we are presenting before the Standing Committee on Local Government, the legislative process that was followed by the department to put this bill together, the impact of the Municipal Systems Amendment Act 2011, the constitutional court that led to the demise of that act, the Amendment Act, and the processes that we followed to revive the bill back in Parliament. And thereafter, then we'll deal with the proposed amendments as they're contained in the bill. Next slide, please. The purpose of this presentation is to brief the members of the Standing Committee on the Local Government Municipal Systems Bill, for noting and to enable the committee to engage, with public engagements, public hearings, and for consideration and to support the bill. Next slide. Next. Before the Municipal Systems Act Municipal Systems Amendment Act was enacted in 2011. Municipal managers and their direct reports, HODs, were appointed in terms of Section 82 of the Municipal Structures Act, as well as Section 56 of the Municipal Systems Act. Both pieces of legislation, that is the Structures Act and the Systems Act, empowered municipal councils to appoint a municipal manager as head of administration and an accounting officer of a municipality, and empowered municipal council to appoint managers directly accountable to MMs. And they prescribed that a person appointed as a municipal manager or an HOD of a municipality must have the relevant skills and expertise to perform the duties associated with their relevant positions. What the Structures Act and the Municipal Systems Act did not provide is the minimum slide. Next slide, please. They did not provide the minimum skills and expertise required of MMs as well as the HODs. This led to different approaches in different municipalities, different interpretations, different HR practices were adopted by municipalities that led to some smaller municipalities struggling to attract, MMs and HODs with the relevant skills to their fold. It also led to the appointment of MMs and senior managers, HODs, who did not have the requisite professional and technical skill to perform their functions. The result of this was under expenditure on capital projects because some municipalities struggled to attract senior managers who could conceptualize projects. Ineffective revenue collecting strategies was one of the challenges, resulting in budgeting municipal debt. The collapse of the rule of law, in surging fraud, resulting in surging fraud and corruption, poor service delivery, lack of consequent management in some areas. Also associated with was the prolonged labor disputes that municipalities had to dispense with from time to time. The minister's regulatory powers also were brought into the fore. I can share an example here. With the regulations that were promulgated by the minister in 2006, performance regulations, they were challenged in a court case that we lost against Umvoti Municipal Council in 2007, stemming around the minimum competency requirements. Can we move to the next slide, please? As a result of these challenges that I've just shared with the members, the department then embarked on a process to come up with a legislative intervention to address some of the challenges that I've just shared with you. A draft bill was developed to amend the Municipal Systems Act, the Principal Act then, 2000. The bill was published for public comment, and comments were then requested from the key stakeholders: SALGA, National Treasury, DPSA, MECs responsible for local government in the provinces, IMATU, SAMU, and the Office of the Chief State Law Advisor. Additional inputs were received from the stakeholders that are listed below. This was a window of opportunity that was open also for municipalities to also submit their own inputs on the draft bill at the time. I would not go into the long list. Safe to say that we received comments, and all the comments that we received from all these stakeholders were then incorporated into the bill. Next slide, please. Upon conclusion of incorporating the comments onto the bill was introduced to Parliament on the 19th of July 2010 in an endeavor to strengthen the capacity of municipalities to perform their functions. The bill was tagged by Parliament as an ordinary bill not affecting the functioning of provinces. That is, it was tagged as a Section 75 bill. The objects of the bill were to insert and amend certain definitions, to make further provision for appointment of MMs and their direct reports, to provide procedures and competency criteria for appointment of MMs and their HODs, senior managers, to provide for consequences of appointment that were made in contravention of the Act, and for appointments that were made in contravention of the minimum competency criteria as set out in the bill. It also, sought to determine timeframes within which employment contracts and performance agreements of MMs and HODs must be concluded, the provision for evaluation of performance of municipal managers and their direct reports. It also required that employment contracts and performance agreements of municipal managers and HODs be consistent with any systems and procedures that are outlined by the minister, that are regulated by the minister. Next slide, please. The bill also required that all staff systems and procedures of a municipality must be consistent with the uniform standards determined by the minister. This was meant to ensure that the policies that are developed by municipalities in terms of Section 67 align with the national norms and standards that are set by minister by regulation. It sought to prohibit, municipal managers and their HODs from holding political office in a political party, to regulate employment of dismissed staff, and to regulate the duties, remuneration, and other terms of conditions of MMs and their direct reports. It empowered, municipal council to approve staff establishment of municipalities. I must indicate here, Chair, that the Principal Act had assigned this authority to the MMs. So the bill, sought to amend it because of the financial implications that always lead to bloating of municipal administration, wanted, to be checked and, authorized, approved by municipal councils. And as I've indicated, the bill sought to assign the power to approve the staff establishment to municipal councils, to prohibit employment of personnel additional to approve establishment of municipalities. But the bill also sought to empower the minister to regulate the human resource management system for local government. As I've indicated in my opening prelude, Chair, this was sought to address the challenge that led us to court with Umvoti municipality, amongst other things, but also to deal with mandating procedures, for SALGA before SALGA goes into wage and salary negotiations. That they should consult with the minister to ensure alignment, between whatever that goes into, or whatever offer that they make in the bargaining council vis-a-vis this remuneration for councillors and MMs and their HODs. The bill also sought to delete Section 82 of the Structures Act to ensure that we've got a single compendium, a single point of reference for all HR staffing matters, to migrate this provision from the Structures Act to the Municipal Systems Act, and to provide for matters incidental thereto. The bill was approved by Parliament on the 19th of April 2011 and was subsequently assented to by the President on the 5th of July 2011 and became into operation immediately. Some of the gains of the, that we had through the implementation of the assented bill had to do more with the professionalization of local public administration, amongst others. But the Act, prohibited the employment of persons against, should I say, additional and against non-approved positions. The bill also provided a competency framework that led a foundation for uniform competency criteria, for senior managers, MMs, and the HODs. It laid the basis for a nationwide skill audit, for senior managers as well, but also provided a framework within which national government and provincial COGTAs can conduct skills development programs. I've already indicated that it contributed to the professionalization of local public administration, but with the bill again, it introduced competency assessment tests that helped in building confidence in recruitment and selection processes that many were doubtful as to their authenticity and whether they were objective enough. So the competence assessment, test supported, the recruitment and selection process to identify candidates, who were who qualified better than others, to deal with whatever eventualities that might arise. With the implementation of the bill, as at the end of March 2019, municipalities across the country had appointed 1,218 MMs and senior managers who met the minimum prescribed competency requirements, across the country, as in terms of the minimum educational qualifications, minimum experience that are required, and they had also passed the competency test that had been prescribed by the minister. The Amendment Act also, brought in a consequent management, framework for appointments that were made in contravention of the Act, and gave the minister and the MECs the authority to enforce compliance, by applying for declaratory orders where a need arises, where municipalities had concluded processes in contravention of the Act. The MECs and the minister, were given an authority through the Amendment Act to intervene. What they would normally do is first ask the municipal council to correct the alleged contravention, failing which the minister or the MEC could then approach the courts, for a declaratory order. As at the end of March 2019, that's before the demise, the invalidation of the Act, a total of 257 corrective measures, that's declaratory orders, were instituted against municipalities that did not comply, that appointed senior managers in contravention of the Act. The Act also fostered participation of senior managers in the PMS, Performance Management System, to maximize the ability of municipalities to achieve their objectives. ensured alignment between individual departmental and municipal performance, but the Act also laid the basis for evaluation of performance of senior managers, vis-a-vis the organizational performance scorecard. And with the implementation, we were starting to see the signs of improved accountability, because once senior managers have signed, the signed a performance agreement which captures the essence of what goes in a municipal SDIB, then those responsibilities were then cascaded to municipal departments, and the performance agreement of senior managers, HODs, also aligned to that of the overall municipal objectives and key performance indicators. Next slide, please. The implementation of the amendment Act also introduced, mechanisms for dealing with substandard performance, consequent management, as I've already indicated, because we had regulations that provided procedures on how we should deal with senior managers who are not performing to the required level, but also maximize the ability of municipalities to achieve their objectives. Brought in uniform monitoring framework, it strengthened, it provided a framework for national COGTA, for provincial local government COGTA department, for SALGA to conduct checks and balances. Once that the framework is in place, the Act assisted us in ensuring that we are able to conduct regular checks and balances. The Act also contributed to building a capable local government, because as required in terms of Section 154 of the Constitution, this framework assisted, gave some legal certainty in terms of how municipalities should approach recruitment and selection of senior managers going forward. The Act also prohibited the employment of staff dismissed for financial misconduct, fraud, and corruption in municipalities, and for various transgressions, which would range, this prohibition, range between a period of 2 years and 10 years in terms of the transgressions, where if a candidate for an CFO position was found guilty of misconduct and dismissed in municipality X, that person will then be blacklisted, from being employed again in another municipality until a prescribed period has been required. And that period, as I've indicated, range between 2 and 10 years, with 10 years being the penalty, or a rehabilitation period that was prescribed for financial misconduct, fraud, and corruption. And the rest of other transgression would then enjoy lesser penalties as prescribed. The ministry, the Act required of municipalities first to maintain a database of dismissed staff, which will then be shared with the MECs responsible for local government, as well as the minister. But the Act also enjoined the minister to establish a national register of all dismissed municipal employees, to enable municipalities, as and when they are recruiting, to fill new vacant positions, to tap on this register to check, because there was a widespread, trend whereby dismissed municipal employees were moving from one province to another and so forth. And it helped a great deal in trying to bring a halt to this kind of movement where we're having a recycling of this kind of rosters, moving from one province to another, one municipality to another. As at the end of March 2019, Chairperson, a total of 1,653 municipal employees who were dismissed for misconduct were uploaded in the database that we use to check as and when municipalities are screening their candidates for appointment. And in the same register, Chairperson, we had a total of 130 municipal employees who resigned prior to finalization of their disciplinary proceedings. Either they were suspended or there was an investigation going on, and they'll just jump boat to avert a sanction. The demise of the bill. In 2013, SAMU challenged the constitutionality of the Amendment Act, as introduced in 2011, on two grounds. The first one was the taking challenge, which we refer to as a procedural matter, because the bill was taken by Parliament as a Section 75 bill, which technically means that it did not affect the functioning of municipalities. The second challenge by some was that of the limitation of political rights of municipal managers and managers directly reporting to them, which was a substantive matter. The High Court of Pretoria declared the Amendment Act unconstitutional, as it failed to comply with the procedure set out in 76 of the Constitution. What this means is that they were of the view that the bill should have been, the act should have been tagged as a Section 76 bill that affects the functioning of provinces, as opposed to taking it as a Section 75. So the court found in the favor of SAMU. But then the court, decided it was not necessary, to pronounce itself on the second challenge, the limitation of political rights of municipal managers. It chose not to pronounce on that one. As many members would be aware, on the 9th of March 2017, SAMU took this matter, to the Constitutional Court to try and force the Constitutional Court to pronounce on the second challenge. Again, there we saw the Constitutional Court confirm the High Court ruling on the taking, that this bill ought to have been taken as a section, the bill should have been taken as a Section 76 bill instead of Section 75, and suspended the implementation of the Act for a period of 24 months to enable the legislature, that is Parliament, to correct the taking defect. The deadline for correcting the defect was 8th of March 2019. And on the 9th of March, the invalidity of the Amendment Act kicked in. The court ruled that the invalidity should take place before the procedural defect that I've just outlined was corrected, emanating from a misunderstanding between the department and Parliament. Briefly, just to explain, what we mean by that, Chair, is that as the Concord order is straightforward. Taking of bills is a responsibility of Parliament, and the Concord said the legislature, meaning Parliament, must correct the taking of the bill because the bill was not taken by the executive, by the department or the minister. So the misunderstanding was around that. In 2017, around October, we wrote a letter to Parliament seeking, its intervention to ensure that the court order is implemented, and there were delays in the response, to that letter, culminating in the invalidity order, coming into effect on the 9th of March 2019. Next slide, please. After the invalidation of the bill, we engaged on a new process we had two options, either to reintroduce the bill back to Parliament or to revive the bill, but we chose to revive the bill with Parliament, which is another procedure that is dependent on Parliament rules. We took the bill back to to Cabinet, which was approved by Cabinet on the 5th of December 2018. That is even prior to the invalidation. We had already seen that we're not going to win, so we initiated the process before the actual invalidation. The bill was certified by the Chief State Law Advisor on the 20th of December and introduced to Parliament on the 6th of February 2018. So by the time the Concord ordered that the bill be invalidated, we had already initiated this process. The bill was in Parliament, from the 6th, and the 5th Parliament started, engagement, consulting stakeholders on the bill, but the 5th Parliament could not finalize the bill, due to it rising, in preparation for the 2019 elections, and the bill lapsed at the last sitting of the 5th Parliament. And we only managed to secure approval of Parliament to revive the bill on the 27th of October 2019. So following that, then the public participation process ensued, and the Portfolio Committee on COGTA, considered oral and written, submissions on the bill during the stakeholder engagements that took place on 26, 27 February 2020 and 4 March. And the stakeholders that made contributions to this were, amongst others, Western Cape Department of Local Government, Gauteng Department of Cooperative Governance and Traditional Affairs, Mpumalanga Department of Cooperative Governance and Traditional Affairs, Eastern Cape Department of Cooperative Governance and Traditional Affairs, and the South African Local Government Association, SALGA. Those were the stakeholders that were present or submitted written inputs that were invited by the Portfolio Committee. Then the inputs of the committee also considered inputs from Limpopo, COGTA, IMATU, IOTA, and SAMU, which was also afforded an opportunity to make an oral presentation, considering that the demise of the bill was as a result of the court challenge that was made by SAMU. The Portfolio Committee again had further submissions from SALGA and National COGTA on the 5th and 25th of June 2020 on the limitation of political rights of municipal managers and managers reporting to them. Although the Portfolio Committee was convinced that the least restrictive means of achieving the professionalization is justified, the committee resolved that this limitation should be expanded to cover all municipal staff due to some of the problems that were shared by some of the stakeholders during the process. The bill was approved by the National Assembly on the 4th of December and was referred to the NCOP for concurrence. And after the first reading and introduction in the NCOP, the bill has been referred to the provincial legislatures to engage in public hearings and to commence processes to obtain their negotiating mandates. And we are here today, Chairperson, in honor of the request by the NCOP to support the permanent delegates, to brief the provincial legislature. The next slide, I think it deals with the proposed amendments. Just before we get into that, let me just indicate briefly that in the proposed amendments, Chair, the black color in the presentation and both in the bill as well denotes original proposed amendments which were submitted verbatim as they were in 2010 when the bill was introduced to Parliament. We tried to avoid a situation whereby the bill, that if we change the original bill from its original, draft status, we would have run the risk of this bill being thrown out of Parliament again. But considering its importance in ensuring that we provide, some governance, HR governance framework for municipalities, we thought it was better to introduce the bill as it was at its initial introduction to Parliament. Areas in the presentation, Chair, will denote the proposed amendments that have been effected by the Portfolio Committee, the National Assembly, and endorsed by the Portfolio Committee and endorsed by the National Assembly. On the proposed amendment, the first thing that I think I need to talk to Chairperson is that I've already highlighted that the Constitutional Court declared the Amendment Act invalid in 2017 for want of compliance with Section 76 of the Constitution. Parliament has tagged the bill now as a Section 76 bill, and it has been classified as such, and we hope this time around it will not create any problem. That's the first amendment that has been made on the bill. Next. On the definition, we're saying the definition of municipal manager as contained in the Systems Act refers to a municipal manager as a person appointed in terms of Section 82 of the Municipal Structures Act. Considering that Section 82 of the Municipal Structures Act will be deleted once this bill has been passed into law, we propose that the definition of municipal manager should then be changed to a person appointed in terms of Section 54A. The definition of political office, as proposed originally from the initial draft 2010, has been amended by the Portfolio Committee, and it reads as follows. Political office in relation to a political party or structure thereof means the position of chairperson, deputy chairperson, secretary, deputy secretary, treasurer, or an elected or appointed decision-making position of a political party nationally or in any province, region, or other area in which the party operates. And it will include any position in the party equivalent to those that are referred to above. I just needed to emphasize that year-coded area is a proposal that has been introduced by the Portfolio Committee, in addition to what the original bill had. Next slide, please. As I've indicated, Chairperson, currently Section 82 of the Structures Act requires a person appointed as municipal manager to have the skills, expertise to perform the duties attached to the MM. Due to the inherent vagueness in this provision, municipalities have appointed managers who are not capable and equipped to provide the necessary leadership to run municipalities and facilitate a culture of responsiveness to community needs and accountability. The absence of clear procedures and criteria for appointment of municipal managers, including oversight, reporting impedes MECs and ministers to exercise their oversight role. So as a result, the original, proposals as were put before Parliament in 2010, their stance is that the bill, proposes to provide, it actually, the bill empowers the minister to determine by regulation the minimum levels of skills, expertise, competencies, and qualifications that will be, that each, municipal manager or acting municipal manager should have, responding to this challenge that we had some vague, the Structures Act, Section 82 was vague. It did not prescribe minimum competency requirements. So the bill, is giving the minister the powers to prescribe that. It also provides, it declares, an appointment of a municipal manager null and void if the person appointed SMM does not meet the prescribed competency requirements. It inserts appointment procedures to be followed, adhered to by municipalities to fill vacant positions. One of them is that they must be advertise the positions nationally to attract as wide as possible a pool of candidates, compile the long and short list, screen candidates, and also ensure that all the candidates are subjected to competency assessment, as I've already indicated earlier on. If the pool of candidates is insufficient for a municipality to appoint, then the municipality will then, in terms of these procedures, be required to re-advertise a position. It provides for the minister to exempt a municipal council from, adhering to this strict requirement, especially municipalities in rural areas. From experience, it's only the Northern Cape so far that has been struggling to attract and retain, suitably qualified senior managers in some of their positions, not all the positions, in some of their positions. And this clause was meant to ensure that in the eventuality of such a case, we have, a window of opportunity on how best we can, because the intention is not to prevent municipalities from building their capacity to perform their functions. It enjoins municipalities to report recruitment and selection outcomes, that is appointments to the MECs, who in turn then report same to the minister, to exercise their executive authority, which in the main is just to ensure that the appointed candidates meet the minimum requirements and that all due procedures were adhered to. Next slide, please. The Section 56 of the Municipal Systems Act provides for appointment of municipal managers and Section 6. I'm sorry, man, I've already jumped to this slide, but let me deal with it just to conclude before I go to Section 56. I've already dealt with bullet 1 of this, and in the event that the MEC and minister find that an appointment was made in contravention of the Act, what the bill seeks to do is to give the MEC and minister the powers to request the municipality to correct, whatever that was not adhered to, was not compliant to the law. And if a municipality does not comply with the MEC or minister's request, then the minister and MEC have the right to seek a declaratory order to declare an appointment null and void. And it also, confers the powers to the MEC and minister to second employees to municipalities to act in positions where municipalities are struggling to fill those positions for longer time. The next slide, please. Clause 3 of the bill deals with Section 56 managers. Safe to say, Honorable Chairperson, that Section 56 of the bill captures the corresponding provisions as that of the MM, almost to the latter. that the same provisions that are introduced for the MMs will then be introduced for heads of departments in municipalities, senior managers. Next slide, please. Clause 4. Thank you so much. Clause 4 of the bill deals with the wording, municipality and municipal council, which are used interchangeably in both section 54A and 56 as proposed in the bill. And we say, they often cause confusion in terms of misinterpretation and sometimes lead to legal disputes. And therefore, this clause has been amended to ensure that wherever reference is made to municipality in section 54A and 56, those words have been amended to refer to municipal council. Next, please. Clause 5 deals with lack of compliance by municipalities with the time frame to conclude employment contracts and performance agreements of municipal managers to ensure accountability. There has been, a trend where there have been inconsistent in respect of the terms of employment contract relating to duties, remuneration, and other employment conditions. And as a result, the proposed amendment is that of substitution of is a provision, to state that uniformly all, employment contract of serving senior managers must be concluded within 60 days of from the beginning of the new financial year of a municipality. While employment contracts must be signed by both parties before the commencement of service the commencement of service. Precisely because of one reason, Honorable Chairperson, is that we have had experience where municipalities and senior managers conclude appointment processes and pick up disputes in signing the service, the employment contracts, and it leads into years into the service of that particular appointee. And often it becomes difficult for municipalities to institute any disciplinary proceeding against the affected senior managers, because the employment contract would have not been active at the time. The bill also empowers the minister to regulate duties, remuneration, benefits for senior managers, and it also empowers the minister to regulate any standards and procedures for evaluation of performance of senior managers. Next, please. Can we move to the, okay. It also provides for, there's a provision here which has been put by an amendment of subsection 6 of section 57 of the Provincial Act, that the Portfolio Committee has proposed that subsection 7 be amended to read that, subject to paragraph B, a municipal council must make a decision on whether the employment contract of a manager directly accountable to the municipal manager must be for a fixed term in accordance with subsection 6 or a permanent basis. What this simply means is that there was a challenge around the previous provision which allowed municipal councils to extend the fixed term contract of MMs to section 56 HODs, section 56 managers. And what this clause seeks to do is that upfront, before an appointment is concluded, municipal councils must make that determination, especially in the core functions of the department, like all other positioning exception of the MM, CFO, technical services, etc., etc. That they need to make that determination upfront as to what will be the status. A decision made in terms of this clause will then be made by the municipal council in consultation with the mayor or the executive, as the case may be. This was a proposal that was put forward by the portfolio committee to address the problem, around instability, lack of continuity, and lack of, institutional, memory in terms of dealing with trying to build the capacity of municipalities to continue rendering their services. Clause 6 of the bill deals with the employment of dismissed staff, and nothing has changed. All what this, the challenge is, as I've indicated in my opening, remarks, is that staff dismissed for financial misconduct, corruption, and fraud moved from one municipality to another without sanction. Government has made a commitment to promote ethical conduct and combat the scourge of fraud and corruption. And therefore, this clause, aims at dealing with some of the challenges. By inserting this provision, municipalities will then be required to maintain, as I've indicated, a database, and once this information has been shared with MECs and minister, there will be, the information will be stored in the National Register, and municipalities will from time to time check as to how far, which which applicants appear in the database who are, prohibited from being employed in a municipality. And we are working on, the work is ahead in terms of trying to have an online system so that this information becomes readily available to municipalities. A municipal employee has been, dismissed for misconduct, ranging, as I've indicated, from 2 to 2 years. They will not be allowed to be employed in a municipality. A municipal employee has been subjected to disciplinary inquiry, but may not be employed in another until the disciplinary process, has been concluded. The minister must maintain a record of all the dismissed staff, including staff that resigned, prior to finalization of the disciplinary processes. I've spoken about, the senior managers who jump boat to avert sanction, and this particular proposal deals with that particular group of persons. Next, please. I've already touched on this aspect that some municipalities are bloated, and that impacts the ability of municipalities to deliver basic municipal services to their communities. And the proposed amendment, as I've indicated, that councils will from now have, once the bill is approved, the powers to approve the municipal staff establishment will vest in the municipal council, and no person will be appointed in a municipality unless there is an approved staff establishment with budget linked to that. Section 67 is also of the Systems Act, Principal Act, is also amended to provide legal certainty with regard to the minister's regulatory powers, as I've indicated, so that we don't want a recurrence of this, legal challenges where we end up being caught for, where municipalities are challenging the minister's regulatory powers. So this has been dealt with in clause 8 of the bill. Next, please. Clause 9 deals with the requirement for SALGA to consult the minister, the FFC, before goes, into wage and salary negotiations. This, as I've indicated, is merely meant to deal with the misalignment of cost of living adjustments that apply to the staff, in municipalities, to ensure that there is alignment. We don't have, one group getting 13%, another getting 2%. That is meant to, amongst others, to address those. But also to ensure that the minister is aware of any shutdown of local government beforehand, if needs be, where there are problems in the bargaining council. Minister should not just see things on the TV and hear on the radio that local government employees have down tools today. Is to create a window for the municipality to be updated on developments in the bargaining council as well. Clause 10 deals with staff members prohibited from holding political office. This clause, as I've indicated, has been amended. It was there in the original bill that was tabled before Parliament in 2010, but it has now been revised by the Portfolio Committee on COGTA in Parliament. And this was meant to deal with the conflation of political and administrative roles by municipal staff, negatively impacting service delivery and governance. We always, want to say the things that we don't want to say, Chairperson, where one of the experiences that we've had is that a driver, a cleaner, a general worker in a municipality who hold a political office, has more authority to give instruction to the MMs, to mayors, and so forth, by virtue of them holding that particular position in a branch, in a region, and that creates problems. And this is what the clause sought to intended to do. And there is a link to that. Is what it's a transitional measure that says, if on the day that the bill is approved by Parliament, assented to by the President, any municipal employee who holds a political office must terminate that within a period of 1 year after the enactment of the bill into law. Next, please. The bill also in clause 11 seeks to clarify some of the areas, the minister's regulatory powers. It added training, competency, skills. It added the competency test, and subject to labor legislation, and it also deals with medical and pension, participation in medical and pension, and to ensure that senior managers also participate in their contribute into their retirement while they're still fit to work. Clause 12 amends Section 106 of the Principal Act with regard to non-performance. It specifically addresses the problem where there are delays by some MECs to investigate maladministration, fraud and corruption in municipalities, and any other serious malpractices that negatively impact governance in such municipalities. So it gives the minister, over and above the authority of the MEC, it gives the minister the power to intervene, to conduct an investigation into maladministration, fraud, corruption, if the minister becomes aware of that. But the first thing that would happen, as provided in the current act, is that upon becoming aware, the minister must request the MEC to conduct an investigation and advise on remedial actions to address whatever challenge. And if the MEC doesn't act, that's where the bill seeks to give the minister the powers to implement this. Next, implement the recommendations of the Clause 13 also, it deals with the minister's regulatory powers. In terms of section 120, it seeks to amend section 120 to put all newly amended provisions in the act. You know, remember the minister derives the powers to make regulation from section 120. So it aligns all those areas that have been amended in terms of this bill, in terms of section 120. And then clause 14 deals with a problem, you know, poor governance challenges as a result of councillors that are voting in favor or agree to resolutions which are before council or committee of council which conflict with any legislation applicable to local government, to ensure that once, you know, municipal councillors, you know, take office, they should abide by their oath of office and the code of conduct that applies to councillors. I think this could be the last slide. And our recommendation, Chairperson, is that this Standing Committee on Local Government of the Western Cape Provincial Parliament note our presentation, consider and support the bill, and while you know, it will be the committee will be taking this into public hearings, and you know, but we are ready to engage the members on the presentation to clarify any areas that honorable members might require some clarity. Thank you.
Chair, you are on mute.
Thank you, Honourable Mr. Ekman. My apologies for that. Thank you, Mr. Mayepa, for the presentation. As you've indicated in your last slide, that this presentation is for noting. We will not engage in the substantive matters contained in the amendments, but we will open the floor for questions for clarity, because after today we will have a separate process where we will engage with the substantive elements of the amendments. So in that context, I would like to open the floor for members who wish to ask questions for clarification only. I recognize the hand of Honourable Maseku and Honourable van der Westhuizen. Are there any other members who wish to request clarification on certain aspects of the proposed amendments? Anyway, let's start. Yes, I recognize you, Honourable Makama Boita. I recognize Honourable Maseku. Please ask your question or questions.
Thank you very much, Chairperson. And again, Ntate Mayepa Raleboga with the presentation. I don't have a lot of questions, Chair. I just want clarity on one thing, not one. I think it will be about 3 or 4.
Please proceed.
I saw on the submissions, I wished if there was any submission from the Vet School of Governance, as we have been, and I know they are working with the local government a lot, that it would have been interesting also to see their submissions on this. And also the Johannesburg University, I looked at the list, I didn't see them, and it will be interesting to find out why they didn't try to submit, whilst they've been leading in training the councillors and the officials in the municipalities. The other thing that I want to find out, there was a slide, I think it's in the proposal of the section 7. It has to do with the permanent or the fixed contract for the municipal manager. I just want to find that clarity because much as we can shy away from it, the MM also works with the fixed contract of the council, of the councillors, whether being the mayor or the whole council. Now, if it's permanent, how is that going to work to make sure that, because I tend to believe that the how do I put this, target setting or the key performance of the MM also have to be evaluated after a certain period of time. Now, if you put me permanent, even if I'm not performing as a MM or the senior manager, that has to be approved. How are you going to evaluate me while I'm permanent? Because I think one other thing that is that has been picked up usually is the slacking and the political motivation that you get. EFF running the municipality, then Al Jama comes in to run. Their modus operandi is different, and you'll find the MMs also getting frustrated with that. Now, when is that MM maybe has been offered to be permanented in that position, or the CFO has been offered a permanent position, is it not going to expose that official to work in a very difficult situation that he won't be able to be effective in really doing their duties? Another one, Chair, it will be the approval. Can I say the approval from the minister or of the appointed senior manager? I just want to find out if they don't agree with what the council have proposed of the candidate, what is there in the bill to empower the minister? And if there is something that is empowering him to give the reasons why he disagrees, but the council are emphasizing that they feel is the right person, what happens in that scenario? I didn't see it that you talked to that, or maybe if you did talk about it, my apologies, maybe you can repeat what you said in those circumstances, what will be the case. Now, the last one, it will be the blacklisting of the official if was dismissed for financial misconduct or fraud or corruption, and period ranging between the 2 to 10 years. Now we've got that one, and I know in government we don't work in silo. When you go to the AG, we pushed for the issue of the debt certificate. Now, to what an extent are you looking at other systems that are being placed in fighting this corruption, that you don't say you rehabilitated a person after 2 years, it comes back? But there was and let's make an example and say you get Rose. Rose has been suspended for has been blacklisted for about 2 years. And Rose comes back and there is a debt certificate that was issued from the AG that has to pay the X amount that is going to last Rose for about 5 years. Are you going to return Rose back? Or what is going to happen just to get the balance between the two, because it talks to the same thing? The title is there, let's say it's a corruption or the fraud on the same matter. So if I can get that in clarity, I think, Chair, that will be, if I remember something that I forgot, I will raise my hand again. Thank you very much.
Thank you, Honorable Maseko. Honorable van der Westhuizen, can take it away.
Thank you, Chair. Chair, I think from the onset, I want to say thank you very much for the presentation, and for me, this is a very important bill because we all know that we experience certain problems in our local government, and this bill certainly as its goal to address some of those serious problems. And I want to say thank you very much for this, also for the initiative to bring this bill. I've got a number of questions for clarity, and I do hope, sir, that our understanding of going into the nitty-gritty and asking questions for clarity is the same. The first one is just there is the issue of the consequences for not signing performance contracts within the timeframes. I saw there that I think it's an existing issue already, that after appointment a performance contract must be signed within 60 days. But there's also now the issue of signing a performance contract within 1 month of a new financial year. And again, I fully support the principle because performance agreements form the base eventually of bonuses. But my question is just, obviously, a performance agreement is a two-sided affair. There's the one party that wants to set the bar as high as possible. There's the other party that would like to qualify for a bonus. And my question is just, is there any mechanism, should there be a stalemate in the negotiations for such a performance agreement? Can it be referred to a third party? Is there somebody that would be able to mediate should those two parties not meet one another? Then on slide 31, Chair, and I don't know if it would be easier if I refer then to the section in the bill. Let me just quickly go there. It's 71B. Staff members prohibited from holding political office. The new wording there is a staff member may not hold political office in a political party, whether in a permanent, temporary, or acting capacity. Now, my question is just, and this is really for clarity, is it the staff member or is it the political office that should not be permanent, temporary, or acting capacity? That's the first one. The second one is, Chair, we often find, and I presume that it's exactly the situation which this wants to address, we often find that political office bearers have in their offices what we call political appointments or appointees. And I think we quite often find that this is a situation where those political appointees do hold office. And I presume then that this has got, therefore now, it tries to address that situation. And therefore, I'm grateful that there would be the 1 year where people will be able to correct the situation. But I do know that many people currently would be affected by this. And then my last question for now, Chair, and I do hope there will be a second round as well. Sorry, I've got two more. Your Schedule 1, voting at meetings, you've got it there down as clause 14, slide 33. The councillor may not vote in favour or agree to a resolution which is before council or a committee of council which conflicts with any legislation applicable to local government. Now, Chair, again, please, I fully agree with the intent. I can see what is meant by this, but we also know that quite often councillors, and it's not only in councils, but that people are unaware of, for example, what certain prescripts in legislation might be. And my question is, first, what would then be the result or the consequences of this? I presume this may refer to the code of conduct, if a councillor should then transgress this paragraph, this wording. But then again, I know up to now where councillors have been held personally liable, it was, because they've been advised or it's been pointed out to them that what they intend to do would be transgressing in conflict with a certain legislation. So I've got a question mark around that. What would be the consequences of such actions? And then lastly, Chair, the whole issue of the regulations, obviously we're not considering the regulations because that's not what is in front of us. But I do take from here that municipal staff members that resign while the disciplinary process is still underway may also be covered in terms of the regulations for reappointment to a municipal council. And again, I think we are having to deal with a difficult situation. On the one hand, we do not want people that are guilty of transgressions to be reappointed in other positions, even though the verdict of guilty may not have been issued at the time of them resigning. But we also do know that, unfortunately, Chair, disciplinary processes can sometimes be abused to try and make life hard for certain individuals. And I'm just wondering whether there is any provision for people to post such a process, be able to, let's call it, be rehabilitated, or perhaps for them to again be able for a third party to look at, whether that was really a vindictive disciplinary process. Because many people, I think, it's an emotional thing to be charged, especially if you're a dedicated public servant, and now suddenly you find yourself on the wrong side of a political party, and you get charged, and eventually you for your own sake just resign, and you want this out of your life, and you want this to be over with, and you don't want the costs of legal presentation, etc. So my question is just in this regard, do people have any way of trying to clean their names except for going through the whole disciplinary process? Thank you, Chair.
Thank you, Honourable van der Westhuizen. Honourable Makamba Boita, you on the floor.
Thank you, Chairperson, and thanks to the presenter, Jackie Maheva. Mine, Chairperson, is just a comment and also seeking assurance from the department on certain aspects of the bill. I do actually welcome the amendments to correct the Structural Act and the Systems Act that did not provide minimum skills and expertise in appointing the HODs and the executive positions. So I actually believe this amendment seeks to combat unnecessary expenditure, irregularities, corruption, and wasteful expenditure being incurred by the municipality as a result of the incompetence of members holding executive positions, because they lack qualification, knowledge, and experience in respective departments. This will also, Chairperson, enhance compliance and adherence to key performance scorecards by various municipalities, which will in turn make sure the service delivery to our poor communities will improve drastically. And then the Act will also assist in doing away with the cadre deployments with no skills and knowledge, even with integrity in executing the mandate of the municipalities. But at the same time, at the same breath, Chairperson, I hope these amendments will actually be applied with integrity that it deserves and not being used as a red tape to disqualify people, even when they qualify based on the color of their skin. And hopefully it will also play a big role in redressing the imbalances of the past, where senior and executive positions are being held by one race. To be precise, Chair, it will also it will assist in dealing and correcting the current challenge of most senior positions that are predominantly taken by the white males. So my comment is on that, Chairperson, and I also need the department to give some assurance based on my input. Thank you, Chairperson.
Thank you, Honourable Makamba Boita. Ms. Kutsi, I recognize your hand, but at this stage, I am only allowing members to post questions. I will give you an opportunity later. So rest assured, I will let you ask questions for clarity. Um, Before the department respond to the questions, and maybe just one or two that I can just add because some of the questions have been covered already. One being that should there be non-compliance with the criteria for appointment of Section 56 managers, and the MEC can seek from the court a declaratory order to force councils to comply. Now, in the event of councils not complying, what remedies are there, and challenge the declaratory order? Um, can the power not be transferred in relation to non-compliance that the that the minister or the MEC has the power to declare the position vacant and or the appointment null and void and the position vacant? That's on the one hand. Secondly, and it will depend on political parties, of course, um, to act against their members who serve in council and who is the governing party within that council, if they allow these appointments to continue without compliance with the legislative framework that is being proposed. And secondly, just to continue with what Honourable van der Westhuizen was saying with regard to the resignations of employees before the conclusion of a disciplinary process. And I want to link it with the re-employment of employees who have been found guilty in a particular disciplinary process. Who's this? And I want to add also that there is a degree of guilt that will determine the length of prohibition from 2 to 10 years. And it was stated in the presentation that for serious infractions, the maximum penalty would be imposed for fraud, corruption, maladministration, etc. The question is, who decide on the appropriate length of prohibition? Would that reside with the disciplinary committee that will make a recommendation to the minister, or does it rest within the power of the minister after having considered the outcome of the disciplinary meeting, what the length of prohibition should be? And should that power be rested with the minister and not with the MEC? And then to conclude with that particular one is that the blacklisting of the disciplined or resigned employee, who initiate that particular sort of process? Is it once again the council, the municipal manager, or the disciplinary committee, or the MEC? Just clarity on that. And then lastly, in terms of the employment of political office bearers, and I concur with the rationale behind it, but and I believe that political appointments within political offices are exempted from the provision, of course, and they will not fall in with a particular sort of amendment. But I want to know what's the rationale for for 12 months to relinquish that executive position within a political party, and why can't we reduce it to 6 months? Thank you, and that's where I'm going to leave it. I'll open up for a second round of questions after the department has responded to the questions. Mr. Maepa and your principal, I don't know if you've captured all the questions, but you are free to initiate a response to the questions, and you can direct. We will be responding to the questions. Thank you, sir. Mr. Maepa, I think your mic is muted, or...
Thank you, Honorable Chairperson.
Thank you.
Can I will deal with some of the questions, and I will leave Ntate Matlashuku to
in order
with the remaining ones once I'm done. Starting first with the questions from Honorable Maseko. The inputs, the written comments on the bill, should I say the stakeholders who submitted comments on the bill are as reflected in the presentation. Remember, the procedure is that once the bill is approved by Cabinet, we then publish it for public comment. It then gets gazetted and it becomes public information. And all members of the public, will derive it. We will write to specific state organs that we are required. The minister is required by law to consult with MEC, SALGA, and municipalities, DPSA, Treasury, and so forth and so forth. So what the list that you have is only those stakeholders that have provided us with written comments. So any stakeholder that does not appear there, it means we did not get any written submissions or comments from them. I'm responding in particular to VETS and UJ. As regards the second question on the permanent fixed term contracts, I'm sorry if I didn't make myself very clear. Municipal managers are currently being appointed on fixed term contracts, and they will continue to be appointed on fixed term contracts. That arrangement will not change. What we were proposing, what the portfolio committee has proposed that be changed, it's in relation to the provision of section 57 sub 7 of the Principal Act, which required municipalities to extend the fixed term contracts of MMs to heads of departments. We were arguing that arrangement does not help municipalities to build the requisite capacities and ensure stability, continuity, and institutional memory. Because every 5 years, when councillors leave, the MMs leave and the HODs leave. In smaller municipalities, there is no capacity that is left to take the municipality forward, the new councils forward when they take office. So that particular section was only intended for section for HODs, that in relation to HODs, we're saying MMs will be appointed on 5-year fixed-term contracts that ends a year after the next elections. But the proposed amendment means municipal council have the discretionary powers to decide whether to appoint HODs on permanent basis or on fixed-term contract, as according to the needs of their own of individual municipalities. There is a question, Honorable Chair, with regard to appointments that have been concluded by municipalities and not approved by the minister or the MEC. First and foremost, let me put this scenario, that according to the Constitution, the powers to appoint municipal employees vest in the municipal council. Not the MEC, not the minister. Council has the powers to employ, so it's the employer. Therefore, the bill has been cautioned in such a way that it respects that constitutional provision that municipal councils are the employers. The question that has been raised, I guess, is in relation to where the bill proposes that once council has concluded an appointment process, they must report that outcome to the MEC, then the MEC will report to the minister. What the bill requires of the MEC and minister is to exercise oversight over that process, to check whether procedures have been followed to the letter, but also to check if the appointed candidates meet the minimum prescribed requirements. So it can only come after council is appointed and not before. Why we saying it can only come after? Because we don't want to involve the minister. We don't want the MEC, the minister, to usurp the role of council. So they can only come after council has exercised its authority as contained in the Constitution. The council has the powers to appoint and not the MEC. So the MEC and minister can come through the exercise of oversight and say, we note that this appointment did not adhere to the prescribed requirement. We note that this appointee does not meet the requirements. We therefore request that you correct this, you terminate this if it's not something that can be corrected, and so forth. And if a municipality does not comply with the MEC minister's request, provision has been made for a declaratory order that the MEC or minister, individually or jointly, they can apply to the court to declare that appointment null and void. In the presentation, I would have indicated that since the Act came into effect in 2011, a total of 257 declaratory orders and just requests for correction, for corrective actions by MEC's minister were implemented and enforced. So the 257, simply put, it means 257 contracts that were concluded, entered into between the municipality as an employer and, appointees were terminated on the basis that they did not comply with the requirement as prescribed. Blacklisting for serious misconduct and the rehabilitation thereof. I know that we probably are using an ambiguous term when we mention rehabilitation. All what the legislation provides is once a person has, has been found to have contravened the code of conduct for municipal staff members, they will be charged with misconduct, and all the rigorous processes for hearing, disciplinary hearings conducted. And if finally that particular employee is found guilty of misconduct, and that misconduct is a dismissible offense, then that's what the municipality will do. And if upon conclusion of that, the law requires, the Systems Act, this bill, requires that the municipality must report that to the MEC, and the MEC will then report, same to the minister, who will put this name in a national database.
Okay.
And make that database available to all municipalities, so that as and when they appoint, they would know which employee is not appointable within a period of 2 years, of 3 years, of 5 years, of 6 years, and 10 years. I'm not sure if I've clarified on that particular, but Chair, I'm not sure. I felt like you're trying to come in.
Okay, for sure, Mr. Mayepa.
Must I continue with the question from Honorable Van Westhuizen?
I'm not too sure Honorable Van Westhuizen will be able to attest to that. But Honorable Van Westhuizen, Honorable Maseko, Honorable colleagues. Makamba Boita, my tongue is dragging this morning. Honorable Makamba Boita, are you reasonably satisfied with the questions, with the responses? Colleagues, I'm also pressed with time. Please, Honorable Maseko, I recognize you.
Thank you very much, Chair. I am certified. Just the last clarity of the question of the rehabilitation. Is the blacklisting just for local government, or is for another department? It's across the board in all the departments in the government, irrespective of provincial, national, or local government.
I think this act it's only applicable to local government. I stand to be corrected, Mr. Mayepa. Can you?
That's correct, Chair. The blacklisting is only for local government, because the minister is only empowered to regulate staffing matters for local government. The rest of others are done by the Minister for DPSA, because he's responsible for those. And continuing from that, there were also questions from Honorable Westhuizen on the consequences for not signing performance agreement within the prescribed time frame. I think in his question, he also provided a response to the question, because the proposed amendment is cognizant of the fact that there are two parties that are involved. You cannot, if the senior manager concludes his agreement in time and submit it to her supervisor in time, he or she cannot be held accountable for failure to meet the prescribed timelines. It will be the supervisor who will have to take responsibility for that. And that's why in the provision, in the proposed bill, there is a condition that says if the senior manager has complied, then he can't be held accountable for that. So there is that clause that clears the senior manager from any wrongdoing in the event that he or she did what was expected of her within the time frame. And the mechanisms as to whether in the case of a dispute, yes, It's more in the regulations, because you'll find provision in the service in the performance agreement that in the event of dispute, then the parties, when they enter into the agreement, when they write the performance agreement, they will appoint, they will agree who the mediator will be in the event of a dispute. So it's provided for in that particular in the performance agreement. Yes.
Okay.
The issue of
Anything else, Mr. Mayepa?
okay, I actually wanted to ask Mr. Mudlashubing to deal with the issue on holding of political office, and yeah, maybe to fill up where I did not deal with.
Thank you.
Person, I will deal quickly with the issues that relating to the holding of the office. The definition that we had in the previous office holding political office. The portfolio committee in the National Assembly felt that because of the positive impact was in relation to senior managers, that has to be extended to all staff members. But we need to clarify this, that all staff members are prohibited from holding political office as defined in the proposed amendment, meaning that of a chairperson, deputy chairperson, secretary, deputy secretary, treasurer of a political party, and a person who holds a position of influence in a political party, be it on a permanent basis or on an acting basis, meaning that it prohibits even staff members from being acting chairpersons, acting deputy chairpersons, acting secretary of a political party. But this does not preclude staff members from participating in the political activities of any political party. They can participate in the political, they can be members and participate fully in a political activities of a political party of their choice. And they can be actively involved, but it is only prohibited in as much as it relates the definition as outlined. And this has also been given a go-ahead in terms of its constitutionality because of Section 36 of the Constitution that restricts certain political rights, or certain rights, not necessarily political rights, certain rights of individuals. So we have tested this, and the Chief State Law Advisor agreed with us that the law or the Constitution does recognize the fact that there should be that particular restrictions of rights of people. And we have seen the success, or rather the positive results of this prohibition when we had it for senior managers, because of what we call the interface between the political and the administrative arm of council. So this is what we are proposing, and it is for the legislature to discuss and see whether this it is in line with their thinking or not. Now, the second question to this is the issue of political appointees. Now, the law does not provide, the Systems Act, as it is at the moment, including the proposed amendments, do not allow what we call political appointees. But what we are saying is that the processes of appointments of senior managers, it is clearly defined in the Systems Act with clearly defined requirements for a person to be appointed either as a municipal manager or as a manager accountable to a municipal manager. And in all those clauses that we have in the Act as it stands today, and is in our proposed amendment, there is no provision for political appointment. So in the Act as it is, there is no political appointment, but only people with the requisite qualification, competencies, and skill should then be appointed as senior managers in municipalities. The other issue was in relation to the voting in meetings. Now, the reason why this is being put is because of the decisions that have been taken in councils that were wrong, and that has got financial implications for municipalities. It is clearly stated, even during the discussion of the chairperson, and also when Councillor van der Westhuizen put it very clearly, that this particular proposal puts municipal councillors in a position of where they vote in favor of any laws, be it in the local government legislations or all laws of the country, and they vote contrary to that. This one puts the burden on that particular councillor for them to be responsible, either jointly or severally, for having taken a wrong decision. And once that wrong decision has been taken, it's very clear that in relation to the code of conduct of councillors, then the MEC must then proceed to institute investigations into the conduct of councillors who then voted contrary to the existing laws. And the possible remedies will then be upon the MEC, whether on which proper sanctions will then be given. But it was to make sure that municipal councillors are voting correctly in consequence or in compliance with the existing laws of the country. Those who resigned before the finalization of their municipal staff members who resigned before finalization of the disciplinary proceedings, the minister, we are proposing that the minister must maintain what we call a database of all dismissed staff members and all staff members who resigned prior to the finalization. And we're also making provision that all disciplinary processes that has commenced must be completed, with or without the official being present. So municipalities are given now in the Act and the regulations that the disciplinary proceedings must be concluded. But if the person resigned, the person's name will be in the database, and before an appointment can be made in municipalities of senior managers and staff members, senior managers, then municipalities will have to check with the minister whether the names of the shortlisted people or the recommended people appear on the database. And the minister will inform the municipality that this particular person's name appear on the database. Because this person was found guilty, or this person jumped ship before the finalization of the disciplinary processes, and the municipality proceeded to finalize this particular disciplinary process. So the consequence is that it is unlikely that people who have been found guilty or who jump ship will resurface in another municipality without us having informed the municipality of such a shortlist, of such a blacklisting. The last one in relation to Honorable van Westhuizen is in relation to whether the disciplinary processes will be misused and be vindictive. We have heard of such allegations in the past. We are aware, to answer you, where does this thing start? The initiation of the disciplinary processes start with the municipality. And the law requires that immediately when this particular disciplinary process starts, then the municipality must inform the minister. So we've got information at national level in relation to all the existing cases and the cases that are to be started on discipline of staff members. But in the event that in our existing regulations of 2014 and in the Act itself, there is no provision in relation to saying that the disciplinary process should not be vindictive. But as you are aware, that the final arbiter in such disputes are the courts, and the person is at liberty where the person feels that there was vindictiveness on the side of the employer to charge him departmentally. Then the person can approach the courts at any given time to challenge the processes that are being done against him. I think the issues of Honorable Nosipo are issues were just comments, and these comments, in my view, are encouraging, and we need to make sure that the implementation thereof are done in earnest, and provincial and national departments are to see to it that municipalities are implementing this amendment should they be ascended to by the president as law. So we'll continue to support and monitor at the national and provincial level, working together to see to it that municipalities comply, and that these provisions have the dignity themselves in relation to make sure that we professionalize local government administration. The last issue is in relation to the honorable chairperson on the non-compliance. As you rightfully indicated, that in instances where municipalities are not complying with the proposed amendments, then the NEC or the minister may approach the court for a declaratory order. Non-adherence to the declaratory order of the court, as you are aware, is a contempt of court, and the processes are there to deal with such behavior. If a municipality defies a court order, that is disrespecting the last order, and the court will be approached to deal with such disobedient municipalities, and the necessary sanctions will then be applied by the court of law. I've already answered the resignation before the finalization of this, but then who decides on the appropriate cooling off period? The minister, in the regulations of 2014, categorizes misconduct in terms of the different categories of misconduct: financial misconduct, sexual harassment, physical assault, and all this. And the minister also gazetted the timeframes for cooling period. So this cooling period is determined by minister as contained in the regulations of 2014. So I've already indicated that the blacklisting will be from that of the minister, but the processes of disciplinary process starts with the municipality and informing the minister for the minister to include that in the database. Thank you, Chairperson and honorable members.
Thank you, Mr. Moslaping. Colleagues, I'm not going to open up for a second round of questions. We're running over time. The meeting was scheduled for 2 hours. We're already 10 minutes over time. But I'm going to allow Ms. Kutsi from Salga. She indicated that she'd like to ask a question for clarity, to ask that question now. And then thereafter, I'm going to ask our legal advisors if they have any comments that they'd like to make, and then we will excuse the department from the meeting and other officials. Thank you. Ms. Kutsi, are you?
Yes, thank you, Chair. I must say my 2 questions was actually covered, but just for clarification, on clause 10, on the staff members that is prohibited from holding of political office. As you know, in the rural areas, that is not public knowledge of staff members that holds office in political offices. And is there any measure or anything that an MM or council would get that information in order to ask a staff member to terminate their office, political office? Is there any measure? Because in the rural area, we don't know. We're not aware of staff members who hold political offices. So is there any measure or any way that management or MM can find it out? My second one was also covered. It was clause 14, the voting at meetings. We're busy with municipal systems, and the clause say voting at meetings. Does that just mean meetings, like budget meetings, LLF meetings, disciplinary meetings, as the previous speaker mentioned, council? Because if voting at council means, because what would the speaker then do if a member or councillor do vote against his caucus? What does the speaker needs to do? Is there anything? Does it just mean we're voting at meetings like LLF budgets, or does it also include council?
Thank you, Ms. Kutsi. Mr. Machupeng, I'm going to hand over to you to respond to that. Or you can direct one of your staff members to respond. Mr. Maepa?
Chairperson, it's me, Tebo Homotlasupe. Just in short, I will indicate to Ms. Kotie that this particular proposal of extending the limitation of political rights to all staff members was sponsored by SALGA, just for your information. But be as it may, I must indicate that in all municipalities, where, for example, what we have done in terms of senior managers, when senior managers apply to be to a position in a municipality, there is a form that is contained in the regulations, and in that it is a question of whether the person holds political office. So the person then will have to declare and sign that the information that he or she has provided is correct in terms of disclosing whether the person holds political office. So it will apply across the board in all municipalities, rural or urban. And in the event that the department at the national or provincial level, or even the municipality themselves, find that the person failed to disclose the holding of political office, it's a misconduct, and the appointment is void and ab initio, because the person did not become truthful at the time when it was expected of the person to disclose the holding of political offices. Once we become aware of it's dishonesty, it's misconduct, and the process of nullifying an appointment will then kickstart. The second portion in relation to voting in municipal council, as you are aware that the portfolio committee councilship, we cannot even at the portfolio committee meetings or the subcommittees of council, you then vote in favor of something that is against the law. That results in misconduct, and such misconduct should be reported. The MEC will then initiate the processes of investigating whether that particular conduct falls within the ambit of breaching the code of conduct or not. So those are the things that we put in place. We're trying to make sure that there is stability, make sure that the local government becomes an employment of choice in the country, and that we root municipalities of all these bad elements that make sure that reputation, good reputation, is maintained in all our municipalities. And Chairperson, as our parting shots, we will be available as a team, this team from national and from the province. We will support the portfolio committee of the provincial legislature when they then consult. So at all times, the administrative team of the portfolio committee will then be giving us the dates, and we will attend all those public hearings with the portfolio committee to give technical support to the committee. Thank you, Chair.
Thank you so much, Mr. Mochla Shupeng. I'm going to, and thank you for your preparedness to avail yourself for further engagements, and we would certainly welcome that. I'm going to ask our legal advisors, Advocate Maasdorp and Advocate Williams, if they wish to ask a question of clarity, and I would recognize Advocate Maasdorp. I see his mic flashing. Advocate Maasdorp, you have any questions?
Yes, maybe an observation and then 2 or 3 questions, Chairperson, if you would indulge me.
For sure. Okay, we'll do that.
Certainly. Thank you, Chairperson. Chairperson, we all know the social political context that necessitates legislation of this nature. We know that there's a breakdown in governance at local level. We know that there's a compromise on resource management, a compromise on financial management, a lack of capacity in general. We understand and know that, and we understand that there's a need for legislative intervention like this to arrest that slide, that downward slide of of disintegration at local level. And I'm pleased to see that part of this legislation includes even legislating the qualifications that certain senior managers at local level should have. Now, if one accepts that something like qualifications are being legislated for, then one must accept that the professionalization of the local level, as far as capacity is concerned, is high up on the list of objectives that this legislation seeks to achieve. Now, what I noticed, Chair, and this is where my question will be premised on, is if one looks at clause 2 in the bill, and clause 2, of course, as we noticed, provides for a new insertion as far as section 54 capital A is concerned. If we see at sub-clause 8, and I will just read it for the record, it says that if a person is appointed as municipal manager in contravention of this section, the MEC must, within 14 days, take appropriate steps to enforce compliance. In other words, Chair, again, we see a legislative imperative imposed on an MEC to ensure that a particular capacity standard is maintained. If a contravention is in place, the MEC must ensure that there is compliance. It says the MEC must ensure this. It's imperative. It's mandatory. In fact, it goes as far as saying that the MEC can even go to court to get a declaratory order. And we know that declaratory orders are only issued by the High Court. So again, there's a cost involved to get to the High Court to ensure compliance of legislated basics, if you like. But then I noticed, Chair, in subclause 9, that it says when MEC fails to take appropriate steps. Now, when I see that, I ask myself, so what will become of this MEC who fails to comply with his own or her own legislated authority? Let me read further. When MEC fails to take appropriate steps, I ask what happens to him or her. But then it goes further. It says, the minister may take the steps contemplated. In other words, the minister may do what the MEC was supposed to do. The question that pops up, other than the fact that what are the consequences for the MEC, the question that pops up is, why in the text of this subsection 9 or subclause 9, does it give the minister only a discretion to act in the role that the MEC should have? Why doesn't it compel the minister equally to ensure compliance? Why is there discretion? That's the first observation. In other words, in the text of this bill, as much as it wants to, through legislation, ensure compliance, enforce compliance even via the High Court, why is there discretion when it gets higher up? And we know, and I will say this not as a lawyer, I'm also a South African citizen, we know how politicized the local government level is when it comes to capacity. Further, Chairperson, clause 6, and I'm probably going to jump around because I'm going according to my notes. Clause 6, employment of dismissed staff. Now, the colleague from the department indicated that a person who has been dismissed for financial misconduct will find him or herself blacklisted and on some or other list for some or other period. And the extent of that period is determined by the minister. That's the first observation. We do know, and this is what is provided for as well, that certain staff members jump ship before a disciplinary hearing commences or is finalized. Now, the colleague from the department indicated that that hearing must proceed for there to be an outcome. But I am of the view that this bill falls slightly short if it seeks to ensure good governance and good resource and financial management. And I say it for the following reason. A staff member who resigns before the finalization of disciplinary proceedings, and this is for financial misconduct, one can then presume that there's been allegations of financial loss to the municipality. In as much as a staff member escapes disciplinary sanction, surely the municipality, it is still incumbent on a municipality to take those steps to recover whatever financial loss there may have been encountered by the municipality. Now, we do know that a municipality is a juristic entity and that it can go to the civil court to claim for recovery of financial losses it may have suffered. We do know that, but we do know it may not happen. Municipalities may not have the funds to litigate for small amounts, but it's still taxpayer amounts. What I would therefore like to see is a provision along the line that says, notwithstanding the resignation of an employee who has been found guilty by a disciplinary tribunal, it is still incumbent on a municipality to take such reasonable steps to ensure the recovery, if any, of funds which may have been lost as a result of a staff member's misconduct. What I'm saying is, in as much as a municipality is a juristic person and that it can go to court if it wants to, if the objective of this legislation is good governance, is financial security and prudence, then it may be equally prudent to legislate, just like qualifications are legislated, to legislate that a municipal council must ensure the recovery, the financial recovery of that loss which it has incurred. Also, Chair, if we talk the talk of compliance, if we talk the talk of good governance and transparency, I notice that a staff member who occupies political office, where political office is defined as it is, must, after the commencement of that particular section, vacate that office within 12 months. And I heard the chair suggesting that it should even be 6 months. Now, those are arbitrary durations. Those are arbitrary thumb-suck durations. 6 months, 12 months, 3 months, 2 days, 2 hours. My question is, if we are serious as this legislation purportedly seeks to be serious about compliance, about good governance, about transparency, why do we tolerate another 6 months of conflict of interest, another 12 months of conflict of interest? How is it not possible that a staff member who is conflicted, knowingly conflicted, does not resign or vacate either position forthwith? I need to understand, why do we indulge a conflicted person for another 12 months after becoming aware of the conflict? Also, there's a further clause, Chair, I think it's clause 12, and this is my last observation, and it ties in with my previous one. Clause 12 speaks to, again, when MSC fails to conduct an investigation within 90 days, notwithstanding a request from the minister may. Again, the question is, Why is it not legislated that there will be consequences for an MEC who fails to uphold compliance? And then secondly, a rider to that is, if the MEC was intended to do something, that is an investigation, why in the text of clause 12 does it only give a discretion to the minister? Why isn't there equally a compulsion, a mandatory obligation on a higher up political office bearer as there is on the MEC? Thank you, Chairperson.
Thank you, Advocate Master, for those valuable observations and contribution. I recognize now Advocate Williams, and then we will then wrap up this part of the meeting quickly.
Good afternoon, Chair and honourable members. Thank you so much for the opportunity. Just to clarify from my side, I'm not an advocate, I'm an attorney. I just have one question for the department. I see in the long title, and it was also made clear in the presentation, that the repeal or the amendment of Section 82 of the Municipal Structures Act was envisaged. However, I do not see the repeal or amendment of that section in the current version of the amendment bill. So I would appreciate it if the National Department could just clarify that. Thank you so much, Chair.
Thank you so much, Ms. Williams. Those, I'm not going to ask the department to respond to those observations. I think that they would take it along with them. And we as a committee and members on the platform will have further engagements on the bill. This is only but the beginning of it. We are way over time. So allow me to thank Mr. Maslu Shuping and his department for giving us a briefing on the bill. I thank Advocate Maasdorp and Ms. Williams for your presence here, and we're going to engage you so much more during the process of dealing with this bill. Thank you for your availability. I'd like to thank Ms. Helen Kutsia from SALGA for her presence and her contribution, as well as Mr. Armstrong. So colleagues, I'm going to conclude with this part of the meeting. I would humbly ask the committee members to stay behind for a few minutes so that we can simply just discuss the way forward in terms of our obligatory public participation process that needs to follow. So with those views, Johan, is there anything that I've just missed out that I need to mention?
Chairperson, no, that's fine. We're good to go.
Okay, good. Thank you so much, colleagues who are going to leave our meeting. I would like to ask the members just to remain behind so that just for the next 5 or 10 minutes so that we could just find agreement on the process forward, and then we will conclude the meeting then. Thank you so much, colleagues, and have a blessed Easter weekend for those who are leaving the platform. Thank you. Johan, let's proceed. What we're going to do now, colleagues, we are going to decide on the public participation process that needs to follow. We have a schedule that we have, or framework that we have sort of worked out that I want to present to you. We need to advertise, and we have circulated a pro forma advertisement inviting various stakeholders to provide the necessary comments on the bill. We will also invite municipal managers and mayors across the province, as well as SALGA and other formations to comment on the proposed amendments. It is suggested that due to resource constraints, that we only advertise in 3 main newspapers in the province. That is the Burger, the Argus, and perhaps the Son, so that we can have a wide reach in the province. And that the duration of the advert should be 10 days. And the duration for advert in terms of, being placed in newspapers for 10 days. And when we return in May somewhere, we could also then decide an appropriate date as to when we're going to deliberate on the comments, written comments, or voice clips, or whatever. And then we will engage the department. And the department will also make a presentation in terms of their position on the bill. And then we will then consider and adopt our final mandate that will be taken to the NCOP. Broadly, that's the proposed path we're going to follow. So I don't know if members have any comments with regard to that proposal. If not, then Johan and I, we will then continue setting the logistical measures in place to reach that outcome. The silence indicates
No comment, Chair.
Agreement.
Yes, agreement, Chair.
Okay. Anyway, Arnold van der Westhuizen, do you have any comments?
I'm in full support, Chair.
Honorable Makamba Boita, do you have any objections to that proposed process?
No, Chairperson. No.
Thank you, members. So, Johan, I'm going to ask, that you and I, we set the process in motion, and then if there's any deviation from that, we will communicate with the members immediately, right?
That's correct. Thank you, Chair.
Could I then also ask that we suspend the adoption of the minutes of the 17th, because we're supposed to be in another meeting at 1, we're already over 1 o'clock, and then at our next meeting we can adopt the minutes.
That's fine by me, Mr. Chair.
Fine, good. On that note, Advocate Master, thank you for your presence and your valuable sort of inputs in the meeting. I think it will assist us quite a lot as we move forward. And Mfundo, thank you for being with us. Candice, for your support. IT, much appreciated. And Ms. Kutsi, thanks a lot. Have a good Easter, colleagues. And remember, the shops close at, I don't know, at 6 today. All the best. And that declare the meeting closed. Thank you, colleagues.
Thank you, Chair.